contracts. These sessions are brought to us thanks to funding from the Australian Government Productivity, Education and Training Fund. And as I said, we'll be looking at what an employment contract is. Why do you actually need an employment contract? The 9 things that you should absolutely include in your employment contracts, as well as the sorts of things we should be leaving out of our employment contracts, as well as some common mistakes and a bit of a Q&A at the end. Quick disclaimer, this information is general in nature. We do recommend seeking professional advice when drafting or changing employment contracts, just to make sure that they are compliant, but also don't include things that they shouldn't include. And a really well-written and well-worded contract is a great way to protect your business. All right. So, what is an employment contract? It's effectively an agreement between an employer and an employee that sets out the terms and the conditions of employment. It can be verbal or in writing. Clearly, a written employment contract is going to provide greater protection to both your business and to the employee. And an employment contract, as much as we would like it to, cannot provide for less than what the minimum legal entitlements are that are set out in the National Employment Standards, modern awards, enterprise agreements or other registered agreements. So we have had some robust conversations in the past with people trying to use an employment contract to negate some terms and conditions. As most of you would be aware, the National Employment Standards provide the absolute bare minimum requirements, and we can't contract out of those requirements. It also, if your employees are covered by an award or an enterprise agreement, the employment contract needs to be consistent with those, or it needs to provide for conditions and remuneration above and beyond what is outlined in the award or the enterprise agreement or the registered agreement. So, do you need an employment contract? And it really depends. If you're employing somebody and their employment arrangement is pretty standard, so it falls underneath the modern award, your business operates under the award terms and conditions, then most of the things that we would include in an employment contract are already covered off within the modern award or the enterprise agreement. So we might do an employment contract if we're looking to include terms and conditions that sit outside of the award or over and above the award to reflect what that employee, what their terms and conditions and remuneration are. So there are a few implied terms, regardless of whether you have a written or verbal contract, and it doesn't matter whether they're stated. So that relationship between the employee and the employer has a few implied conditions. The first one of those is that the employee will act in good faith and conduct themselves in an ethical and proper manner while they're working for your organisation. There's an implied duty that the employee will obey all reasonable orders or instructions, as well as using appropriate care and skill to undertake their work. It also implies the employer's duty of care to provide a safe workplace and to make sure that the employment arrangements are legal and compliant, as well as reasonable notice in terms of resignation or termination of employment. So a verbal agreement or a letter of offer might be sufficient for both parties. However, if you are operating outside of an award or an enterprise agreement, both parties will be better protected with something in writing. We've had some really tricky situations where there has been a verbal or an implied agreement between an employee and an employer, and that's great when the relationship's going well. However, if the relationship was to take a turn or potentially an employee becomes, experiences some financial hardship, that's when it can sometimes backfire. We had this with an employer who thought that they had an independent contractor relationship with somebody. That relationship had carried on for many years. That individual then experienced some financial hardship and then turned around and said to the employer, no, actually you owe me annual leave and personal leave entitlements for the last 6 years. And because nothing was in writing, it was very difficult for the employer to defend that. So an example of where a letter of offer might suffice is if we're employing somebody under the hospitality award, for example, and the letter of offer might be something along the lines of, we'd like to offer you employment. You'll be covered by this award at this grade, and this will be your hourly rate of pay. Your terms and conditions will be governed by the award, as well as workplace policies and procedures. Having a 6-page employment contract is probably a bit of overkill for a straightforward role like that. But if that is what your organisation wants to do, then there's no reason why you wouldn't have an employment contract instead of a letter of offer. So there's a few things that we recommend keeping out of employment contracts. So enterprise agreements or modern awards, because they automatically apply. So it doesn't matter if you have that in the contract or not. If there was ever a question as to what award or enterprise agreement somebody was covered under, Fair Work would make that determination. We have had a few cases where an employer thought that they could cover somebody under a different award because it was in the employment contract. That is not the case. We strongly advise keeping policies and procedures out of the employment contract. A couple of reasons for that. The primary one is if you want to change those policies and procedures, you effectively need to change the employment contract to go with it. The other thing that I saw in an employment contract the other day, which we recommended changing, was it had the mileage reimbursement rate as 88 cents per kilometre, when in fact what we probably want to refer to is the ATO rate for mileage reimbursements, because then when the ATO changes that rate, the employment contract is still valid, whereas if we have that 88 cents and the ATO changes the rate, then there's a bit of a mismatch between what's in our contract and what the actual practice is. And we also leave employment-related legislation out because you cannot contract around that. So all of those things are implied as part of the employment relationship. I also had an organisation that had a leave policy, so evidence and notice requirements are in the employment contract. They were very generous and they wanted to change them. And so in order to change them, they needed to reissue new contracts to everybody. And as a result of that, there were people that refused to sign the contract because the terms were obviously a little bit tighter in terms of evidence and notice requirements. And that left the employer in a challenging situation because if the employee hasn't signed the contract, then it doesn't take effect. One of my colleagues was also telling me about an example where somebody had put in an employment contract that the employee would be entitled to a brand new vehicle of a specific make and model. And so when the employer tried to give them a near new vehicle of that make and model, the employee pointed out that that's not what the employment contract said. So we don't want to back ourselves into a corner by putting too much information in our contracts. So the 9 things that we absolutely should be including in our employment contract is the position. What are we hiring that person to do? What is the status of that position? So is it casual, part-time, full-time, fixed term? Including a probationary period. We'll talk a little bit more about these in a minute. The location of work and thinking about where you want that person to be able to work. If you have multiple sites or there's a likelihood that you might need them to travel to other locations as part of their role. We want to sort of cover some of that off in the employment contract. So if we're too specific and we say your place of work is 200 Newtown Road, Newtown, with nothing else in it, that would mean that the employee could then say, well, I'm not working from there because my contract says I work here and only here. The other thing we should have in our contract is the remuneration and general obligations, which I'll talk about in a minute, termination clauses and conditions. Most of the time it will be in accordance with the National Employment Standards, but you might like to have some other notice periods included in there. And also what grounds might constitute termination in a very broad sense. We cover most of that off with our policies and procedures outside of the contract. The offset provision, I will talk a bit more about this because this is absolutely critical if you're paying above award, to ensure that we have the offset provision in our employment contract in case we might forget to pay an allowance or something along those lines. The offset provision provides a little bit more protection for us. As well as the right to alter, and I'll talk to you about the things that we want to have that right to alter in a minute. We've got a bit of a list. So they're the 9 things that we would include. If you were going to look at your employment contracts and you have all 9 of these things in there, then you're pretty close to having what you need. You might want to add some other things depending on the nature of the role. So if you've been following along these series, you would know that there's been some changes to the definition of casual. So when we are employing somebody, we need to make sure if we're employing them as a casual, that it is genuinely a casual relationship. And that is that there is that not an expectation of ongoing employment. So just be careful if you've sort of got into the habit of just bringing everybody into your business as casual. You may or may not be may or may not be on the right side of the legislation. So if you're employing somebody and you have an expectation that you're going to continue to employ them in your business in somewhat of a regular fashion, it might be better to have a look at a part-time employment status instead of casual. Full-time or fixed term, and there are a series of rules around fixed term contracts. So things like if you're doing a parental leave cover, then that's a very genuine reason to use the fixed term contract. If somebody's role is funded through a grant funding or something along those lines, or if it's a particular project. But if you're just rolling over from one fixed term contract to another, then you might need to consider whether or not those individuals should be full-time instead of fixed term. The Fair Work website actually has a really useful fact sheet on fixed term contracts, as well as the exemptions for the use of fixed term contracts for government funded roles. So the probation period, most employment contracts that I see have a probation period of 3 months, which is very fine and dandy. There is a difference between your internal probation period and the Fair Works minimum employment period. So probation is that time that we use early in the relationship to make sure that this is a good fit, both for the employee and for our business. However, under the Fair Work Act, there is a minimum employment period that applies, and that's the period in which an employee needs to be employed for in order for them to make an unfair dismissal claim or to apply for unfair dismissal. So if you're a business with a headcount of 15 or more employees, that's 6 months. So in theory, if you were to employ somebody, it wasn't working out and the relationship is terminated for legitimate reasons within 6 months, that employee cannot make an unfair dismissal claim application. If you are a small business, so a headcount of less than 15, that minimum employment period is actually 12 months. Now, that's not a get out of jail free card. You can't just go sacking people left, right and centre within their first 6 or 12 months. You still need to terminate under probation for a legitimate reason that is not something that could be deemed discriminatory. So when you are terminating under probation, we strongly recommend giving a reason for termination, but that reason has to be a reason that would not give rise to a general protections claim. So I don't know if somebody's been sick a lot in their first few months of employment. We can't terminate somebody for being sick because that's a workplace right, and that would potentially give rise to a general protections claim, which is different to an unfair dismissal claim. So one of the things I like to use, because generally this is why we might terminate under probation, is that somebody's not responding to feedback. They're not sort of seeing the improvements that we'd like to see. So yes, so that's your probationary period. So you can keep it at 3 months if that's what you normally use, bearing in mind you have that minimum employment period to kind of assess somebody's performance. If it's not working out, make that decision within 6 or 12 months. So as I said, the minimum employment period applies regardless of the length of probation. So our employment contracts templates outline some pretty general obligations. And the conditional offer of employment sits around the fact that the person actually has working rights in Australia, that there's no restrictions on the commencement of the agreed date. This is quite important. I've seen this happen a few times where somebody's supposed to start on the 1st of July and for whatever reason they can't start until September. When you've got that clause in the employment contract, it gives you a bit of a get out of jail free card. If you're like, I don't want this person now, if they can't start in July, I need to find somebody else for the role. As well as no limitations on their ability to perform that role. So if somebody has said that, I don't know, they can lift 25 kilo boxes and they're fit as a fiddle, and then they start working for you and go, well, actually, no, I can't do that. Then it gives you, again, an out clause from that employment contract. as well as that any information that's been provided for you to make the decision to hire that person needs to be accurate. And if somebody has said that they've got, I don't know, a bachelor degree in widget making, and then you find out that they haven't, then that would also give rise to the termination of that employment contract. That applies to qualifications, licenses and experience. And that gives you, the employer, the right to terminate that contract if the above conditions aren't met or found to be untrue. And interestingly enough, most universities, you can actually jump onto their website and do a search to prove that somebody has the qualifications that they have stated that they do if it's a university degree. Or you can, there's ways that you can assess the validity of, like a certificate qualification as well. So there's some of the general obligations we include. The other condition that we have is that right to alter. So there's usually a clause somewhere at the end of the contract that says we've got the right to alter the position, the reporting arrangements, the position description, the location and the responsibilities in order to meet the needs of the business, provided that those alterations are reasonable and then within the employee's skills, knowledge and experience. So, I can't ask somebody to go from, I don't know, working in the office, taking bookings for our delivery drivers to becoming a delivery driver of a medium rigid truck if they don't have a medium rigid license or, the ability to operate that kind of equipment. But it's good to keep it in there because, as we know, we often do need to make alterations to people's roles or responsibilities that kind of still sit within the salary that we're paying them. But due to business needs, we need to make changes. So it's important to keep that clause within our employment contracts to give us some flexibility. The offset provision, as I said, this is one of the most useful clauses you can include in an employment contract where you're paying people above award wages. And that's something we're seeing a lot more of now. In order to be competitive in the market and attract quality people, we're seeing people paying a bit above award. And it's very important how it's worded because different awards and industries will have different allowances and penalties and leave loading requirements. So it does need to specify every single thing within that modern award or enterprise agreement. Probably wouldn't do one of these under an enterprise agreement, more likely under an award. And it's basically talking that we've given you compensation for all your entitlements that might be under that award. So I worked at the building company once. They were paying their staff, I don't know, $5, $10 an hour over the award wage, but they weren't paying leave loading. And so one of the employees raised that with the employer to say that we're not getting leave loading. But because the employer had this offset provision built into their employment contracts, they were able to explain to the employee that we're actually paying you above award so that we don't need to worry about things like leave loading or I don't know, the various obscure allowances and things that pop up in modern awards. I think I mentioned this last time that I was doing some stuff for the cleaning award and you get an extra allowance if you're cleaning a toilet, which you would not really anticipate if you were paying a cleaner. You would kind of just assume that their hourly rate would include them being able to clean toilets, but that is not so. Another good reason to seek some advice around remuneration, including allowances, so that we don't miss any of them. But as I said, it really needs to be specifically worded for full protection for that clause. So there's a number of other clauses that you may or may not want to include. Really depends on the nature of the role and what sort of arrangement you have in terms of what they're being paid in some cases or what sort of things they might have access to. So our employment contract templates now include a right to disconnect clause for people that are on salaries where there's an expectation that they would be contactable out of hours and respond to out of hours contact. All modern awards also have a right to disconnect clause in them as well. You might have a performance clause. You might have reference to company equipment, but would be using the word may. So, TCCI may provide you with a mobile phone and a laptop to undertake your work. We expect you to look after these or whatever it might be, but using the word may so that if you don't, then you haven't got this issue like the brand new car. You might put a clause in there about expenses. So, approved expenses will be reimbursed. If you've got a company credit card, having a clause in there about that. This doesn't need to be War and Peace. It's really just a paragraph. If there's a requirement for somebody to have a current driver's license, so if you've got a business where people must have a driver's license to be able to perform their role, we would recommend having something about you must maintain a current Australian driver's license, because if somebody lost their license and then they can't do their job and you don't have the clause in there, then you're in a bit of a grey area. Whereas if you do have that clause in there, then that gives you the ability to be able to terminate employment if you can't find something else for that person to do if they didn't have a driver's license. You might have a clause in there about drugs and alcohol. This would not be a drug and alcohol policy. I would be keeping that separate, but it might be a simple statement about the use of drugs and alcohol in the workplace. A clause around deduction of money. So if you're an organisation that does nice things and gives people advances on their pay or their leave or those sorts of things, strongly advise you having a clause in there that gives you the right to deduct anything that they owe you from anything that you might owe them at the end of employment, as well as a clause around the return of property or resigning directorships and those sorts of things, just to make it nice and clean. Like, yes, it's implied that you're going to give back the keys to the office or the shop front or whatever it might be, but it doesn't hurt to have it in your employment contract. So you might also think about a restraint of trade clause if there is a risk that somebody might leave your business and go and try and poach some of your clients. However, you need to remember that the stricter you make that restraint of trade, the more likely somebody is going to try and dispute it, and the onus is on you as the employer to justify that. So the restraint of trade is that not being able to approach people, your clients, for a certain period or within a certain distance from your place of business. So it might be you can't approach anybody in the widget making business within 50 kilometres of the Hobart CBD for 6 months post your employment. These are very difficult to enforce, but they act as a good deterrent for people to sort of think that they're going to come into your business, find some of your customers, leave your business and take the customers with them. A confidentiality clause, if you've got people that have got access to confidential information or confidential client information, including that. Intellectual property, if somebody develops something when they're working for you and you want to be able to keep it. So if you're running a restaurant and they come up with, the world's best schnitzel topping and you want to be able to keep that recipe as yours because you were paying the person at the time. So it's your intellectual property, not theirs. Some of you might be old enough to remember, I think it was about 20 years ago, there was a big dispute with a high-end restaurant that's no longer operating about who owned the recipes that were developed by the head chef. Having this clause takes away that grey area. If you want to surveil people in the workplace, either electronically or through cameras or microphones in the workplace, it's a good idea to declare that in the employment contract. And if you want to have bonus or incentive schemes, that you need to be very careful with how you word that. So this person may participate in a bonus scheme or, our business might, at our discretion, pay this person a bonus. I would not be naming up the amount and I would be very careful about the language. So it's not, this person will get $5,000 every 6 months or something along those lines, which locks you into something that you don't want to be locked into. So this is why we recommend seeking advice, because for some businesses, none of this stuff is applicable, or for some of you, maybe 1 or 2 of those things are, but not all of them. And you really don't want to put things in there if they're not applicable, but you also don't want to leave them out if it's something that is relevant to your business. So if you want to make changes to employment conditions, I had a really good question the other night from somebody that each year with the 1st of July pay increase, they issue brand new employment contracts to every single person in their workplace. If you're just changing somebody's remuneration, you don't need to issue a new employment contract. You can just send them a letter that says confirming that from this date your new salary will be da-da-da-da-da, or your new hourly rate will be da-da-da-da-da. Thanks very much, have a nice day. So it's kind of like an addendum to the employment contract. So if it's a minor change, then it doesn't necessarily need a brand new employment contract. However, if I was going to be changing somebody's role or their employment status, I would be giving them a new employment contract. So that's sort of a case-by-case basis, but yeah, you definitely don't need to be issuing new employment contracts if it's just a pay increase. Given that a lot of people have one on the 1st of July every year, that seems like a lot of admin for no great benefit. So some of the mistakes we see is that people put too much information in their employment contracts. The more things you put in there, the more likely you yourself might find yourself in breach of your employment contract. So if you put in your employment contract, I'm going to do a performance review with you every 12 months, and you don't do that performance review, you're actually in breach of your own employment contract. So if you're going to review your employment contracts, have a look through them and make sure you feel comfortable with all the things that you're committing yourself to. The opposite is also true. Sometimes people don't put enough information into their employment contracts if there's things that they want to establish that are outside of the award or the national employment standards. If you still have pay secrecy clauses in your employment contracts, you do need to update and reissue them. So that is now illegal. You can have something in there about it's your right if you wish to share your remuneration or your employment terms and conditions. However, this is not compulsory, but you definitely cannot tell people they're not allowed to share their pay details, because that was a legislation change probably a couple of years ago now. And there was a nice little window, about 2 to 3 years, for workplaces to update their employment contracts to remove those pay secrecy clauses. As I said before, businesses not adhering to their own contract requirements. That reliance on verbal agreements, if it's not in writing, it didn't happen. And that applies to anything to do with workforce management, workplace relations, HR, industrial relations, whatever you want to call it. Don't rely on verbal agreements. As I said before, that offset provision is a really important part of employment contracts. And sometimes we find contracts are written in really complex language. A contract can be just as valid written in plain English as what it can be written in legal jargon. And in fact, it's probably a better protection tool for your business and for your employees if it is written in a way that people can actually understand it. So there's some of the common mistakes. The biggest one I would say is actually not having an employment contract or not having the terms and conditions of employment actually in writing in the form of an employment contract or a letter of offer. Something along those lines. So some things that I would suggest you do as a result of this session is reviewing your employment contracts, and while you're at it, reviewing your remuneration. So we've got a pay increase coming on the first full pay period from the 1st of July. So that's 3.5% for award covered employees. Those pay guides will be available on the 1st of July. So we'll send an email out to our database. So if you get emails from us, you'll get an email with all of the hyperlinks to the new pay guides with the new rates of pay. Also a good time to remind you that the super guarantee will be increasing to 12% as of the 1st of July. And that's another thing when you're wording things in your employment contract. When I'm talking about super, I wouldn't name up a percentage. I would say that the superannuation contributions will be made as per the applicable legislation or as per the super guarantee or something along those lines, so you're not locked into an amount. Remove any unnecessary or illegal clauses that you might have in your contracts or things that might come back and bite you. Ensure that you've got an offset provision if you are paying above award. It's a really good idea to consult with your employees when you're going to, if you're going to reissue employment contracts though. I was working with a business last year and they hadn't done anything with their employment contracts for years, and they were not great employment contracts to start with. And so we gave them some new templates and worked with them to customise them to the business. And because there wasn't any consultation, everybody just got issued with new employment contracts. There was some real pushback from the staff. So I got an email with something like 27 questions about why is this like this and why does this say this and we don't agree with this and we don't agree with that. And everything in that employment contract was perfectly legal. But because there was no consultation with the employees, there was kind of this underlying suspicion that the employer was trying to do something dodgy. So if you are going to update your employment contracts, it's a good idea just to chat with people and explain why you're doing it. and give them some reassurance that you're not taking anything away from them. You're just making sure that the contracts are accurate and reflect the employment relationship. And in some cases that they're compliant with current legislation in relation to what you can and can't put into an employment contract. If you can, try and develop or access template employment contracts so that you that template customised to your business, but you want to make sure that they're consistent. So everybody that's casual in your business has the same kind of employment contract, or your full-timers or your salaried staff, and it's the name, the job title, and the remuneration that might change. But then if you've got, 3 or 4 different 3 or 4 templates, then you can be kind of rest assured that they're going to be compliant. Whereas if you're cooking one up or Googling one or ChatGPTing one each time you employ somebody, you might find that you've got some inconsistent terms and conditions in those employment contracts. Interestingly enough, on the business.gov.au website, you can actually download an employment contract template. I think you fill in a few fields and it will actually give you an employment contract template, which is not a bad starting point for you to work out what you want to add to that, but it will give you the bare minimum. So not a bad little free service from the government. If you are listening and are wondering what you are going to do and you would like some help, if you are a member, you can access the Workplace Relations Helpline. You can contact us. We have a whole raft of different employment contract templates, from really simple ones through to more complex ones for, I guess, roles that have a lot more aspects to them that might pose a risk to your business. And we also have our Employer of Choice Assist funding. So if you have got a business with around 19 or less FTEs, if you're a little bit over, we can work with that. Then we can help you at no cost. It's a great service. We'd normally charge you a couple $100 an hour for this kind of work, but with thanks to the Tasmanian government, we can do that for you at no cost. And as usual, government funded, they love a bit of feedback. So if you feel like giving us some feedback, please scan the QR code or maybe wait and see how well I answer your questions if you have any. I'm just going to you over here. All right, that was a lot of information for Monday morning. Are there any questions about employment contracts?